All right, good morning. This is Thursday, March 18th. Time moves on. It is nearly springtime here in Bennington County. Everything's gone, all the snow's gone, but it's supposed to snow again tonight. So we will see. That's your weather forecast from Bennington, but it was 59 and beautiful yesterday. I went outside and did part of my meetings outside yesterday. So
Oh, wow.
that was a change. Today's meeting is on H20, which is a bill that has to do with pretrial risk assessment. And I believe tomorrow we take up CSG's recommendations in Justice Reinvestment 2, which would further probably amend this bill with some other risk assessment issues that were in the Justice Reinvestment 2 report. So we're going to start with Eric Fitzpatrick, who drafted the legislation and worked with the House to pass it. So Eric, turning it over to you to walk us through the bill.
Yes, sounds good. Good morning, everybody. This is Eric Fitzpatrick with the Office of Legislative Counsel, as the chair said, here to talk, do a walkthrough of H20 as it passed the House. H20 is an act relating to pretrial risk assessments and pretrial services. One thing I just would add, also based on what you said, Senator Sears, about tomorrow, the CSG testimony. The bill you introduced on that has got a number, so you may or may not want to have Peggy add that to the agenda.
We should use our number then.
Yeah, Peggy, it's S127.
Thank you, Eric.
Yeah.
Great, thanks.
That just got the number, so figured I would pass that along. So so on H20 though, as it passed the House, this is deals with a couple of different aspects of risk assessments and pretrial services, including needs screenings. The big picture is that, as I'm sure the committee knows, it's worked in this area quite a bit over the last couple of years. Generally, under current law, it's a requirement, it's mandatory that a defendant, a person who's been arrested charged with a crime, very often the person is being detained. That person is required to be offered a risk assessment and a need screening. So in the big picture of what's going on with this bill, a couple of things are happening. First of all, and I should say that the risk assessment that is required to be offered, mandatory that it be offered, has to do, it assesses two different things. It assesses the risk of the person's non-appearance at trial, right? The risk that they're not going to appear in the proceedings as they go further along, and it also assesses, whether the person presents a risk of reoffense. So you've got two separate things: whether the person is going to appear or whether they're going to reoffend, and that's under current law what the risk assessment does. So I explain that because to understand what H20 does, it does two different things with respect to risk assessments, and it, in the big picture, it seriously, significantly narrows their use. So I think, sort of speaking generally, the House Judiciary Committee heard testimony that there were concerns about the reliability and potential bias involved in risk assessments generally. And on the basis of that testimony, I think they concluded that the right direction was to scale back their use. And they scaled back their use in two primary ways. First of all, as I mentioned, the current law provides that risk assessments, they have to be offered. It's mandatory that they be offered to defendants who have been lodged for 24 hours. The H20 makes that discretionary. So they don't have to be offered. They may be offered. And not only is it discretionary, but they will not be used for assessing risk of reoffense anymore. It would only be used to assess whether someone presents a risk of non-appearance, that they might not return to the court proceeding when they're supposed to. So those are the two big picture things that are done with respect to risk assessments. With respect to pretrial services, the other part of the bill, what that does.
Before we go there, Eric, can I
Yes, please.
ask some questions about the risk assessment?
Yep.
This is based upon what? Because the reason we put risk assessments in was this theory that judges and others didn't know who and what problems were presenting them. And I remember, a lot of discussion about if you were having a heart problem, would you want to be judged without any assessment as to what the best treatment is because of your heart problem? So you go in with signs of a heart attack and just say, okay, this guy's got signs of a heart attack. We're not going to bother with any tests or any information. We'll just go ahead and do what we think is best. And so, I mean, it was based upon scientific evidence. So is it that risk assessments are no longer reliable? Did they have evidence of that? Or was this just, I would really like to hear some national testimony on that. I find this to be, quite frankly, particularly if you don't think you can assess the risk to reoffend. Did they have scientific evidence on that? Who did they hear from that determined that?
I think that I don't know that there was scientific evidence, but I think there's at least some anecdotal testimony or anecdotal evidence and some evidence based on their use in Vermont that, again, I don't have any way to independently assess that evidence, but I think that if you hear from David Scher and Willa Farrell, they might be able to.
This to me is a huge step backwards in Vermont, trying to look at issues from a risk assessment basis. Maybe the tools we're using are not good. Before I can support this provision, I need to hear some national data and what was that guy's name from the University of Cincinnati? Ed Latessa.
Has he testified before? Is he someone we could contact, perhaps?
Well, he's somebody that I know, and if you could get his contact information, I can see if he or somebody else can testify.
Yeah.
Ed Latesse, he's world known. I can check also with the Justice Center when we're talking tomorrow with David Diamora would know him.
Right.
Ed Latesse, University of Cincinnati. Peggy, just Google him, would you please?
Can you spell the name for me?
Oh God, don't ask me to spell the name.
Or say it again louder so I can hear it.
I think it's L.E. Latessa, L-E-T-E-S-S-A, I'm guessing.
And the first name?
Ed.
Ed, from the University of Cincinnati.
Yep.
Okay, I'll see what I can find out.
Yeah. This is like taking huge steps backwards, in my opinion. I'll listen to the testimony.
Sounds good. The second issue that's addressed in the bill has to do with pretrial services and need screenings in particular. And this is connected to the work that the committee's done over the years, that the legislature actually also has done over the years, to expand juvenile jurisdiction. So I'm sure you recall that as time is going on, certain offenders who are charged with crimes who are 19 years old, 18 years old, and 19 years old will be able to be treated in the family division as juveniles rather than charged in the criminal division as adults. However, pretrial services, risk assessments, need screenings, those sorts of things are not available to persons charged as juveniles because the family division, persons charged in juvenile proceedings, have their own set of services. Those are available to adults. So the idea was not to inadvertently exclude, say, an 18-year-old and a 19-year-old who happens to be charged as a juvenile instead of an adult, to allow them to get pretrial services, need screenings, just in the same way that they would have been able to get if they were charged as an adult. So that's all that does. That's a relatively, almost in some sense, a technical adjustment, just to reword the statute in several places so that 18 and 19-year-olds charged as juveniles would also be able to access pretrial services. So that's the second piece. Now that really describes in the big picture, and we can certainly look at the language if you like, Senator Sears. There isn't, just to see how the language reflects what I just described in the big picture. Or you can turn right to witnesses, whatever you want to do. It's fine with me. I think the bill is on, I assume the bill is on the committee's page, so I can pull that up and we can look at it real quick, or whatever your preference is.
Yep. Committee, would you want him to walk through the bill and with it on the screen, shared screen?
Half the bill, so.
Yes, especially given that we're on YouTube with an audience.
Sounds good. All right, let me do that then. And I'll pull it up. So here we have H20 as passed by the House. As I mentioned, the House proposal essentially phases out pretrial risk assessments in most circumstances, except for the one I mentioned, when they're used only to assess risk of non-appearance and it's discretionary rather than mandatory. And so because the risk assessments are phased out, most of the references to risk assessment in the statute are deleted. So you can see, for example, in subdivision A1, strikes the language that describes what the objective of pretrial risk assessment is, because the language had said that it was to provide information for purposes of determining whether the person presents a risk of non-appearance or a risk of reoffense. That's the third line down, the third struck line. So the court can make appropriate decisions on bail and pretrial release conditions. So since, as I mentioned, it's being scaled back, the use of risk assessments generally, the decision was to remove most references to risk assessment and just refer to need screenings in most cases. You'll see the one instance right there in subdivision B1 is where it's retained. The use of risk assessments is retained. So it's the instance that I described earlier. So it says, and this is the new language, judge may request the pretrial services coordinator to perform a risk assessment that assesses risk of flight. So you see the two changes are right there in that phrase. It's may, first of all, judge may request. So it's not mandatory anymore. If you looked at the bottom line on that page, the struck through line, you see it says, had said, shall be offered a risk assessment. So the shall becomes a may. That's change number one. And change number two, you'll see that the risk assessment that assesses risk of flight. See, so it's not assessing risk of reoffense anymore. It's discretionary and assesses only risk of flight. And it applies only when a person is arrested, lodged, and unable to post bail within 24 hours. Now that part is the same. That's when they had applied before as well. But the scope of who would be offered one is scaled back because it's not mandatory and it's only assessing risk of flight. So that's that. Sorry, go ahead.
So take the guy's case that we talked about during our deliberations on S3rd, and we heard from the mother of his victim, Danny Pronto. The only thing that they would assess on him is his risk of flight, not his needs.
I think that's correct.
That just, so, he just murdered somebody or allegedly murdered somebody. And we're only going to assess his risk of flight.
Can I ask a question? I mean,
Yeah, please.
does victim safety,
No,
come into play at all?
no.
I'm not sure as far as the risk assessment tool and what factors are assessed, whether it be, what goes into that conclusion. I think it'd be better for some of the witnesses who actually use those tools and know how they work and what circumstances are evaluated to reach a conclusion. So I don't know what they base it on, but the conclusion is only, are they a risk of flight or not? So that's, again, the language on risk assessment is struck again at the end of that same paragraph, same concept. And you'll see that it is struck in several other places as you move through the statute. See subdivision 4, subdivision 5. Now, subdivision 6 goes to the second piece of the bill, which I had mentioned, which is making clear that that pretrial services, and again, if you look at the very bottom of the screen, that's existing language, but these are the people who may choose to engage with the pretrial services coordinator. Again, that's, I should have mentioned this at the beginning, that it's not mandatory that the person, actually follow through and engage with pretrial services or risk assessment. You can't impose that on the person. They can't require it. Can be required to be offered as it is in existing law, but the person can always say no. And that concept is preserved in the law. This is, the person may choose to engage. It's offered. That doesn't mean they have to accept it. But this language makes clear that, and this is the new underlined language, that as far as the people to whom it is going to be offered, it's going to be also, it adds to the list, a person 18 years age or older who is the subject of a delinquency petition. So again, that brings in that group that I had mentioned, that because of the change in juvenile law, some 18 and 19-year-olds are going to be able to be charged as juveniles in the family division. If they had been charged as adults, they would be offered pretrial services and they could engage. So you don't want, the idea here is not to, is to still offer them pretrial services, even if they are charged in the family division with a delinquency petition. And I think that's it. And this, yeah, and this new language you see in subdivision D, that's just boots and suspenders, really. That's the same concept that I just described. It's just rewording the language to make sure that it includes everybody in that group that I just described. Anybody who's eligible to engage with a pretrial services coordinator, just rewording it so that it broadly includes all of those folks.
So we're going to do risk assessments on those, on that group, but not on the other group, unless the judge orders it. That correct?
I didn't quite follow that one, Senator Sears, sorry.
Where this bill would allow risk assessments on the younger group, but not on the older group. The judge can't order a risk assessment except based upon risk of flight on somebody who's been jailed for more than 24 hours. Is that correct?
Yes.
So it can't do a need screening, can't do a screening of risk of reoffense.
Well, I think the need screening is separate. I think that as far as pretrial services and the need screenings, those folks would still be able to obtain it. It's the risk assessment piece that's scaled back.
I see. Okay. His name is actually Latessa. That's Edward.
Latessa.
Yep. ESSA.
Thanks.
Whoop, somehow I lost the meeting. Here we are.
Make sure I didn't miss anything here. Yep. Act takes effect on passage. So yes, that's all the
Right.
language in the walkthrough.
Well, yes.
Should I pull the document down?
Yeah, that's fine. Our first witness is David Shear, Assistant Attorney General.
Good morning, Senator. Good morning, committee. For the
Good morning.
record, David Chair, thank you, with the Attorney General's office. And this was a bill that the request for which came out of our office, and it did have the agreement of the stakeholders that you see present today. Let me give a little bit of context for why this request came through and what is current practice in terms of where we're coming from here. It's important to remember that, first of all, that the risk assessments and need screenings are two different things. The need screenings are working well. They are being used widely. They will continue to be used. And in fact, part of the impetus for this bill is to make sure that our staff have the as much capacity as they can to do need screenings and all of the services that can result from that. The issue with the risk, with the risk assessments, is that they are not being used by anybody who's a party to these cases, and forcing them to be done in what is really a relatively small number of cases anyway, but which took up a decent amount of time because it required staff visits to facilities. Forcing these to happen when they aren't being used didn't feel like a good use of time, and we are hoping to redirect energies towards the parts of the program that are working very well. And the reason why they're not being used, and other folks who are up for testifying can speak to this more as well, is that they aren't reliable. They're not reliable for a couple reasons. One is that the way Vermont is working here is that our program staff do not have access to criminal records. And that's a key part of these, of producing an accurate risk assessment. And there's a bunch of bureaucratic reasons for that. There's some federal law reasons for that. It would be, frankly, very expensive to try to implement the security that would be required to allow staff to be able to access criminal records. So it hasn't been a part of these risk assessments. And largely as a result, judges are not relying on them. Defendants are not using them to argue in favor of release. Prosecutors are not relying on them. So the idea here is simply to make them, they'll still be available under this bill if a judge wanted to do it, or if it maybe a defendant could ask a judge. Although the reality is, and again, others here will testify to the same, we don't really expect them to be used at all, even though the option is here. The other aspect of unreliability has been increasing discussion really around the country about risk assessments potentially embodying bias and coming out with judgments about people that reflect bias around race in particular. And that's in that although I would say that the sort of main concern driving this is the fact that they simply really aren't usable right now on the way Vermont is set up. That is a secondary concern as well. And while the concept of risk assessments and having a sort of fair baseline judgment about risk is a good concept, it isn't working in Vermont. And until some of those bias issues are sort of worked through nationally, we think it's a good idea to put a pause on the mandatory aspect of these for now. And so that's a sort of overview on where we're coming from here. And then the second part of this bill, which we do think is important and has garnered less discussion, is just ensuring that everybody over 18 still has access to pretrial services. Again, that was the intention when this was written. When youthful offender and raising the age for juveniles came in, there was a disconnect between the intention and the language, because those got written after this statute was written. So now this is just bringing this statute back into line with the original intention, was that people who are criminally justice involved generally and over 18 will have access to pretrial services. So that piece, I think there's been less concern and discussion about. But on the risk assessments piece,
Can you provide me with the actual documents regarding bias? It's anecdotal, it's not. You provide us with the documents that led the Attorney General to decide that risk assessments are no longer, that they're not being used. I would like to see the documents. You said that it was, that risk assessments have bias built in, et cetera. What is the documents?
I don't have that research off the top of my fingertips.
I would like to see the
provide you
research. I would like to see the research that led the Attorney General to go in this direction.
And to be clear, Senator, it was not, our decision. We are so during the pandemic, we haven't done these at all because our staff can't enter the facilities. But setting aside that, assuming we're going to get back to normal again, it wasn't our decision not to rely on these. It was courts, and it was practicing prosecutors, and it was defense attorneys and defendants who have not relied on them and aren't using them because they don't have the information they need. So we're simply reflecting reality, the reality of practice in courts, and trying to bring this into alignment with the practice in courts, and not having our staff do something that the practitioners, the judges, lawyers, prosecutors, defense attorneys are not relying on and not using.
I'm trying to understand, and I need to, so we decided risk assessments aren't valuable if we spend all that time determining that risk assessment will be valuable. Typical, and wonder why our results are what they are.
And again, when we think about risk assessments, it's important to remember this is really focused on the bail decision, which is about risk of flight. The language was sort of aimed towards that. And so that's the only context in which these were even theoretically going to be used anyway. They weren't, there's other contexts in our system that still use risk assessments and actually rely on them. But in this context, the only usage that they were even theoretically being put toward was the bail decision and thinking about risk of flight. And again, for bail in particular, only risk of flight can be discussed. It's not constitutionally proper to discuss public safety issues when you're talking about bail. And again, because this didn't have a sort of key piece of what you need a risk assessment to have in order to use, it simply wasn't being relied on, even for that relatively narrow purpose. So again, these risk assessments were always sort of aimed at a narrow area that we're trying to look at, an important one certainly, but it's really about the bail decision, and anchoring that bail decision, in a sort of measurable way. But again, the way the sort of lack of completeness around these have rendered them not usable even for that relatively narrow purpose. And I do want to emphasize the need screenings are moving forward. They are working well. Our staff are providing, I would say, good services, and services that other parts of the system really rely on. And again, I'll let Matt Valerio and Judge Grierson speak to this as well, but they're providing good services in terms of connecting people with services they need, mental health, substance use disorder treatment, and also helping people meet the conditions that are set out for them by the courts, helping them get to court appearances and so forth. So, it's important to remember that big chunk of what pretrial services is doing and has really evolved into a focus on is working well and is being relied on by the court, by the various practitioners involved.
Questions? Thank you.
Thank you.
Next, we have Judge Grierson.
Good morning, committee members. Thank you for inviting me to testify on H20. For the record, Brian Grierson, Chief Superior Judge. I would, well, let me start by putting the population we're talking about in context. I was looking at the numbers today. The total state detainees, 282 today. That represents 23 females, 259 males. And I don't know the exact number. There's 12 people on detention. I don't know the exact number out of that 282, but I'm guessing that there's approximately 200 people being held without bail. That number hasn't changed much over the last year, despite the pandemic conditions. That number of 282, I'm sure there are others that have a longer history with the numbers than I do, but that is a pretty low number in my experience. So we're talking about roughly 80 people who are being held on bail. And as David said, the whole purpose of the risk assessment, at least in the context of this bill, relates solely to determining, it was supposed to be for determining risk of flight and to be a factor in the court's decision, judge's decision in setting bail or not setting bail. But the reality is that if you didn't adopt this bill and left it the way it is, although it mandates risk assessments under the current language, the reality is I don't know if we've ever seen a risk assessment. And the primary reason is that, as I understand the tool that is being used or was contemplated to be used, I believe it's one of the ORAS tools, one of the elements that were required was the criminal record history of the defendant, both the in-state and out-of-state. And my understanding is that there are significant barriers to getting the pretrial services folks, I don't want to use the word licensed, but using that term loosely, the ability for them to gain access to those records, I understand, well, it doesn't exist. And I understand that it would be extremely difficult to get that. So the courts have not been able to look for the risk assessment as a tool in determining bail. So by striking this provision, it's really not changing or adopting this amendment. It's, to me, it's more in recognition of what is going on in the courts. I'm not familiar with the literature that David referred to, but my understanding is even if the literature says risk assessments are a valid tool for this purpose, the tool that is being used in Vermont wouldn't assist us because the pretrial services people cannot access all the information they need in order to provide us with that assessment. So we're not using, and they have not been for those reasons.
This is just on bail.
Yes, yes, they are used in other parts of the system. DOC uses them to a risk.
What about prior to sentencing?
They're not necessarily used at sentencing. And when I say that, remember the data from the justice reinvestment folks was about 90, what did they say, 95 to 99% of the cases are resolved by agreement. So when those cases come to us with a plea agreement and sentencing, there's no indication
So I
That
go
there
back
has
to
been
my,
risk.
so, okay, so when you're having a bail hearing, then some of this may be understandable. Again, I'll go back, I get Pronto would probably be being held without bail, I guess. But I'll go back to this. Justice Reinvestment 2 also suggested prior to sentencing, we do risk
Yes.
assessments. Now, at risk and needs assessments, you know,
So
if there's not valid tools to do those, it's troubling because my example of the heart, you walk into the emergency room with a heart attack, wouldn't we want to know what caused it before we open your heart up and do some stuff? I mean, we would certainly do a lot of tests and determine.
I would
you know,
hope so, but I
I
think
would
you
hope
have
so
to,
too, but on this, we're doing guesswork, I guess.
well,
Sentencing people to 18 months to 2 years for 10, I've forgotten the sentence, for beating a 63-year-old man with a baseball bat. Couple of down in Manchester, there's one left to be sentenced. The two that were sentenced to 18 months based upon plea agreement. One of the plea agreements was rejected by the judge, but it was all, time served. They went in, beat this guy up, and did all that, and got 18 months. Was that based upon a plea agreement or based upon what the needs and the risk of these two individuals were? There's a third one yet to be sentenced. That's where I'm having trouble with this, that we're, instead of basing it on what the risk is, we're basing it on, when the judge rejected the other plea agreement for 12 months and sentenced the guy to 18 months, he said that was what the other guy got sentenced. So it certainly wasn't based upon any risk assessment or anything that would be logical. And I really, this is where I'm if you can't tell, I'm frustrated by the system's refusal to look at risk.
so Senator, I'm not familiar with the case you're referring to, but I
Well,
think,
there were three guys who beat a 63-year-old man up, ostensibly because of drugs. And now this guy, because his name's been out there, people think he's a druggie. I don't know that he is or wasn't, but he's the victim. And two of them have pled, and the first one got 18 months to, I think it was 10 years time served because they'd already done 18 months. And the third one has yet to be sentenced, but the prosecutor recommended 12 months and the judge rejected that plea and sentenced the guy to 18 months because that's what the other guy got.
so I think one of the things the committee needs to keep in mind is if we're looking at this bill, we're only talking about risk assessments at the time that bail is set. And that, in my understanding, is that it's the inability of the people providing that assessment to have all the information available to them to provide a meaningful assessment. But on the other hand, what you're talking about is sentencing. That's a place where, by agreement or otherwise, the Department of Corrections have the ability to access information so that they would have the information to provide that type of assessment.
But if the risk assessment is biased or isn't valid, according to David Scher, for bail hearings, then why is it valid and not biased for other hearings? For sentencing?
That's why I said I'm not familiar with the literature that David is referring to, but I can't disagree with that last point. But I think there's a difference between the resources available at the beginning of the process for pretrial monitors to be able to access information for a risk assessment versus the Department of Corrections when you're looking at even at a plea agreement, although they may not be in custody of the department at that time, they have the tools to be able to do an assessment if you're contemplating bringing someone into their system or custody. I think that's where there's a big difference in resource availability.
Okay. Other questions from the judge? So, Alice,
So apparently, are any of those evaluation tools, are there any of them that are different and don't require getting all the person's history prior to it? You know, the criminal history?
Senator, I'm not familiar with all the tools, but if you think about it, the issues around bail and the risk of flight, the issue, the information around a person's criminal history, both in and out of state, would be a significant factor in the court's determination. So any tool that did not have that information, we would still have to consider that. So I think in that tool, it's definitely necessary.
So in terms of the risk of flight versus the people who are being held without bail, I mean, is that simply because of what they're charged with, that they are not being offered bail? It's not just flight then?
The people being held without bail,
Yes.
that's because of the nature of the offense being a serious offense and that a determination by the court that there's a high, I'll use the term probability of strong evidence and an inability in the court's view that conditions of release can protect, keep the public and or the victim safe. So it's a different criteria that we look at for a certain group of the most serious offenses.
So the judge decides that on his own, are you saying? I mean,
Yes, the judge makes that determination. There can be hearings. In other words, if there's an initial hold without bail, the defense is entitled to a hearing on that. The court then the trial judge makes a separate determination. And then that decision, if the decision is to hold without bail, they do have the right to appeal that to the quick appeal to the Supreme Court.
using any kind of pretrial assessment. They're just basing it on the evidence.
No, that's right. That's right.
Yep. Okay. Thanks.
so, but they have a weight of evidence hearing, and what do we
Yes.
do?
Yes.
So the weight of evidence hearing is not based upon their risk, but based upon the evidence that they may or may not have committed the crime.
The strength of the evidence, nature of the charge, and the ability or non-ability to comply with conditions of release. In other words, are there conditions of release that could address?
Keep the public safe, you said.
Yes.
Right.
Yeah.
How do we know without a risk assessment? That's, I guess, going to be my next question.
Well, again, since we don't have a risk assessment.
Somebody's doing a risk assessment. Let's take this case. A judge in his own head, at the recommendation perhaps of the state's attorney or the attorney general or the defense bar, is making a judgment and making a risk assessment without information about the risk that could be available in other ways. And that's what doesn't make sense. So I'm making a risk assessment based upon other information other than a risk assessment. That's professionally done, that has been, nationally recognized. And I really, I'm not trying to be argumentative. Maybe I am, I don't know. But I'm trying to get convinced that everything we learned about risk assessment was wrong.
And again, I can't tell you that it's wrong. What I can tell you is that the people that are being asked to do that risk assessment at that stage, and by that I mean the pretrial monitors, don't have for lack of a better term, the credentials or the ability to access the information that is part of that assessment. And that's why we don't have them. It's not that they can't be done or they can't be useful, but we're going to have to authorize. And David mentioned there's a significant, there are federal and requirements around record histories and who can access them. So that's the question I think that has to be resolved, is how do we get that information into the hands of pretrial monitors, and what what expense and what is involved in that. And again, I don't have that information at hand, but I understand, I've heard the same thing. Even when we originally talked about this bill, that's one of the issues with the risk assessment at that stage, as opposed to sentencing when corrections, if they are asked to do the assessment, because the person is potentially coming into their custody one way or another, either on probation or into the system, they have the tools to be able to do the assessments.
But their risk assessments are okay, but you're not, probably not the one, that probably the Department of Corrections needs to be here as well in the next. On this bill, because I don't they, I mean, at sentencing, back in the day, you used to get a pre-sentence investigation, right? And they're limited now. You get a few of them.
They're required in sexual assault or sexual
Right.
offenses,
Yeah.
but the court can still order them if, in other cases, if they want
But
to.
one of the reasons that we did away with the requirement in other cases for pretrials for pre-sentence investigations was because we had this tool called risk assessment. I'm going back here when we first started this whole idea of risk assessment was going to be something. We used it for kids, we use it on everybody, and now we're saying it's not valid anymore.
Well, I thought, and I could stand to be corrected with the Justice Reinvestment, that they were looking at the idea of coming up with I'll say a briefer or not as detailed pre-sentence investigation that
Right,
would
that's the
include.
pilot.
Right.
The two, I think, well, that's S-127 that we're going to talk about tomorrow.
Right. So I guess what I'm saying is, if the tool was available to us, the court would obviously take it into consideration. But my understanding is there are limits on the ability of the pretrial monitors to be able to access the information. I understand the focus, certainly, of this discussion has been on the use or non-use of the pretrial risk assessments, and it is an important issue. I think the back end of the bill that talks about pretrial services, I would just inform the committee that I think that the services provided by the pretrial monitors has been beneficial, because it's giving folks who come into the court with substance abuse issues, mental health issues, the ability to address those issues and make the connections necessary to hopefully keep them from coming back into court. And it's probably beyond the scope of this bill, but I have discussed with the Attorney General's office and with Willa Farrell, one of the issues that I keep seeing, and this committee, others have touched on it, the use of conditions of release. We spend an awful lot of time, this committee and others, on expungement and removing the consequences of criminal convictions. And when we look at the front end of the system, the conditions of release that are applied, and in my view, there's a question of whether there's an overuse of conditions that leads to multiple charges pending. And if they result in convictions, we're talking about $150 every time there's a conviction on a violation of condition of release. I don't know that, I stand to be corrected again, I've ever seen a trial on a condition of release, meaning they're applied, violations are brought, and they become essentially a negotiating tool, but they have significant consequences to individuals down the road. And the question is whether there's some of these conditions of release that could be addressed through a more robust pretrial services program. A lot of those offenses are status crimes. Somebody hasn't had a license for 10 years and they're driving because they have to drive to get to work, and they're charged with driving with a suspended license. And it's almost routine, accepted by the courts, by the state's attorney, by the defense attorneys, that they'll have a condition of release not to drive. And you really have to ask yourselves whether that has any impact on someone who has to drive. Wouldn't they be better served if instead of that condition, they were referred to the pretrial services monitor to work on what is it going to take to get this person reinstated? So I'm getting a little far afield here, but I think the pretrial services program has certainly proven beneficial. There may be ways of expanding their services and perhaps minimizing the need for conditions of release that really don't serve any purpose. So with that, I'll be quiet and open to any questions.
Okay.
Senator.
Darn, I was muted. Any questions for Judge Gerson? Okay, Eric, I know you have to leave at 10. Oh, well, let me just finish this thought. Eric, I know you have to leave at 10, but you can pick us up on YouTube later.
Yeah, sounds good. Thank you, Senator Steers.
Thank you. Peggy or I will try to remember what it is we have questions about for you. Thank you.
Yeah, well, that is one of the, looking forward to coming back, when we can, but one of the advantages of YouTube is you can watch the hearing when you have time.
Well, we'll see you tomorrow morning.
You bet. Thank you, Senator Steers.
Thank you. Okay, Jeanette.
So given what Judge Gerson was just saying about the conditions, why do we continue to do that? I mean, we know that it sets people up for failure, and yet we continue to do it. What does it take to get people to stop doing that?
Change the law.
I'm at a loss here. I mean, the defense knows it, the prosecutors know it, everybody knows that it's setting people up for failure, and yet we do it as a matter of course.
Put in a bill.
I have to, I'm going to please keep it going, Senator Ruth. I have to move to a different location.
Okay.
Senator Benning has a
I
question.
wish I had an answer for that, Senator White, but I don't.
Judge,
Go ahead, Senator Benning.
it may just be my imagination, but have we been seeing an uptick in weight of the evidence hearings as well as condition of release modification hearings?
I can't answer that with any certainty, Senator Benning. I will tell you that the hold without population seems to have remained fairly constant over pre-pandemic, during the pandemic, and now. As I said, I'm only guessing at that number, but the last time I checked, which was about a month ago, the hold without population was right around 200. So I don't know that it's varied much from that. We've had resolutions of some cases over the course of this pandemic. So that number has remained fairly static. I don't know if there's been an increase. As far as modifications of conditions, again, I'm not sure. You may be seeing that in the courts you work in.
Well, I'm definitely feeling it. I don't know whether it's system-wide, but in the same vein as the question that Senator White asked, we are seeing conditions imposed that are almost guaranteed to set people up for failure.
Mm-hmm.
The number of VCRs, which are violations of conditions of release, for those that may not know, seems to be increasing dramatically. And it may just be my sole practice, but I have this distinct feeling, because I read the newspaper here, that there is definitely an uptick in VCRs, and I'm curious to know whether we're monitoring that.
Well, I did some checking. I'm waiting for a final answer there. I can tell you the information I have so far, there was about 3,000 violations of conditions of release last year. I believe that's the number of charges filed. I don't know what the conviction is. I'm trying to narrow that down, and I can certainly provide that information. But even if it's just charges, I mean, that's having an impact on whatever the underlying case is that brought the person into court, because they have a way of continuing. You've seen them. They generally speaking, they end up with multiple VCRs. I mean, I've seen plea agreements that are 3 pages long that I've sat on, where there might be one underlying significant offense, and then two pages of violating conditions of release because the case has gone on for whatever, year and a half. And many of these are, they're status offenses. There are conditions of release that are significant, that are important. No weapons, no firearms, no contact with individuals in cases involving violence, domestic violence. There's no question of the importance and the need for those types of conditions. But these conditions don't drive unless you have a license. If the person is picked up while they're on release, they'll be charged with a new crime.
A curfew violation.
Curfew violation.
What's the rationale other than the number of VCRs as they rise become leverage for the prosecution in trying to force resolution of the underlying charge that was the important charge? And it's very frustrating when you see a list of violations that really didn't have an impact on whether the person was going to flee the jurisdiction or cause some other harm. So I'm just expressing frustration.
Yeah, even if you view them as conditions relating to public safety, I'm just saying that telling someone who hasn't had a license in 10 years not to drive, I don't think is in making the public any more safe for that person driving or not driving. Telling an alcoholic, don't drink. It's I'm not sure what the answer is, but it's something that, we talk, how much time have we spent talking about surcharges? For that 3 pages of plea agreement, we're talking about $1,500 in surcharges, even if they walk out of the courtroom on probation with no fine.
Right.
They're looking at $1,500 in surcharges that cannot be waived.
I think
Senator
this needs to be a continued conversation regarding conditions of release, but I'm not sure unless we do an amendment that's in this bill. But I would suggest that that's part of what I think has lost in many quarters the faith of the public. They see people out, they're constantly charged with violating conditions of release and they're released again. And the public says they're not, can't keep doing this. So anyway, Senator White.
So I just was going to comment on what Judge Gerson just said about the condition for alcoholics to not drink. Actually, there was a Supreme Court case about that said that you can't use that as a violation. You can't put that condition on. You can only put the condition on if it impacts that they can't drink to the extent that it impacts their ability to function or whatever it said. I can't remember what it is now. And yet it's constantly put on. I mean, and there was a Supreme Court case about it. So it baffles me.
I brought the issue up only in the context of the pretrial services program
Right.
has been working. And I
sorry.
think there's room to say that they could do more for a lot of the issues that otherwise end up with a condition of release being imposed. So anyway, I'll be quiet.
Well, we'll hear from Matt Valerio on why his clients are violating their conditions of release.
Thank you.
Matt, H20, if you have comments.
Senator, if I might very quickly, David Chair, I just wanted to apologize to the committee. I have a commitment I need to run to, but Willa Farrow will keep representing the AGO in this hearing,
Right.
and I will be sure to watch it and be ready for any other questions. I know this is a important topic to you and the committee, and I'll be back. ready to
Appreciate
answer
that,
any
David.
questions.
And I think we'll see you tomorrow morning anyway. Actually,
Sounds
you're
good.
not scheduled, but maybe you should drop by. We're
Sounds
taking
good,
up
Senator.
the justice reinvestment issue of risk assessment. Matt,
Morning.
thank you for being here.
Yeah, no problem. I was anticipating coming in and giving you, Senator, exactly what you always want, is a simple little bill. Because every person who is involved in this on all sides came in to the legislature this year in advance, agreeing to what this was supposed to do. And despite what I thought was even excessive vetting on the House side, which is not unusual, it came out pretty much unscathed and doing what we anticipated it would do. And then this morning to hear it whistle into a tailspin in the very first mention of what it is attempting to do, I was surprised. Let me start by saying that what the bill addresses is actually a very narrow, small group of people where you're supposed to be getting risk and needs assessments within 24 hours, and those are only for people who are held without bail for more than 24 hours. Right. So it's a of this group of the numbers of cases that we go through the system. That's a very small number. But what the bill was attempting to do was to recognize a couple of things. One is what the practical practice has been since these assessments went into place, and then have an understanding now with risk and needs assessments pre-trial particularly, and it's a whole other issue post conviction and pre-sentencing. So you should, although many of the issues that are problematic regarding racial bias and the like still exist in those, we're not talking about those. That's not what this is about. This is about pre-trial release. And there have been a lot of studies, and I have provided a good number of them to the AG's office from think tanks, law schools, and universities all over the country that talk about how the systemic racism that we have as part of the criminal justice system gets baked into risk assessments. And I'll just give you a simple example of how this works. I'm pulling just some numbers. If we say, for example, that non-whites get arrested 5 times more than whites do by law enforcement on the street, and that they get searched 6 times more than non-whites get searched 6 times more than whites in the same context. That is a decision made on the street that impacts criminal history. So every single criminal history going forward bakes in the objective decision-making made by law enforcement on the street. And in aggregate, it perpetuates itself throughout the system. So when you end up in a situation where, and this is what risk assessments, when they are supposed to work, are supposed to do. They don't tell, a risk assessment doesn't tell you what an individual's risk of reoffense or showing up in the future is going to be. It doesn't tell you about that individual. It only tells you what the aggregate group of people who look like the defendant have done in the past. And if you have baked in bias into that aggregate group of people who look like that defendant in the past, you have baked in a systemic bias to a system that is going to continue to hold people of color, and it bakes in other biases as well, by the way, relative to socioeconomic status, poverty, homelessness, so on and so forth, into the system going forward. And so there are literally scores of articles that have researched the mathematical inevitability of the bias being baked into these risk assessments. Now, that wasn't the biggest reason why this bill came forward. The biggest reason was pragmatic. As a practical matter, people weren't requesting these risk assessments. They didn't have the criminal justice histories to even make an attempt at using them. And as a result, they were trying to codify what existing practice was relative to these people. The issue, some of the things that you brought up, Senator, regarding, I know this Punto case is on your mind a lot because we talk about it a lot, but it is one case that doesn't define the system. It is an outlier, and I think that you need to, I say this a lot, and I've said this for 20 years. You can't make policy based on outliers. And I'm not sure that a risk assessment in the Punto case would have made any difference either way. So that having been said, there's a lot of research out there about the issue. The simple part of this bill is it's codifying existing practice, and it is putting us on a road where we are starting to recognize the implicit bias that's baked into these risk assessments as a result of the factors that are being considered relative to predicting future behavior of an aggregate group as opposed to the individual. And that's all it does. You've brought up a whole bunch of other issues, and Senator Benning brought up some good issues about conditions of release. That, I know Judge Grierson and I've had this discussion many times about conditions of release and their overuse and the like. That's not this bill. That's not what this is about. It's another issue. It's related because it has to do with arraignment and release, but that's not what this is about. And this isn't about sentencing. This is about whether or not somebody should be released on bail. It's that simple. So, that's how it was, to me, it actually doesn't do anything one way or the other to our relative to the rights of our clients.
Well,
either way, because if they want a risk assessment, they just ask for it.
My obvious question then is, if risk assessments have bias built into them and systematic racism, then what are we to do in making decisions at sentencing if we don't use risk assessment? Don't we then build in all the biases that are inherent in the judge and the rest of the criminal justice system in determining whether this person should get 18 months or 2 years or 10 years or life or whatever the decision is?
Well, I
thought that risk assessment helped us make choices in terms based upon, as you said, and there may be racism based in there. Don't discount that if there are studies that indicate that. But then what do we do? How do we make decisions about how long to sentence this individual for? And what is, in the judgment of that person's rehabilitation, but also that, protecting public safety, and if there is any element of deterring future crime.
Well, I assume we're not talking about this bill anymore because you're talking about sentencing.
Well, I am, but if risk assessment aren't good for, if risk assessments contain systematic racism and bias, then how can we use them for other things?
It's a piece of a bigger puzzle. You understand the difference between a psychiatrist and a psychologist, right? A psychiatrist.
Pretty much. One's more expensive than the other.
Yeah. Well, the MD gives you another zero on the end of your bill, I think. But psychologists use all kinds of tools that have been developed, questionnaires, MMPIs, all sorts of tests and the like to attempt to get at a diagnosis. And what is the primary tool of a psychiatrist? Well, they use the clinical interview as the primary tool to make the decisions that they make. The combination of the two is what is going to be presented to, in theory, and I'm not talking about criminal justice as a whole, but the judge is a decision maker taking in all of the factors that you have, anecdotal evidence, and tests, and there's bias built into the tests. The easiest and most unfortunate thing you can do is just say, well, the test is science, so we'll just rely on that, because it gives everybody cover, and you don't have to make the hard decisions about what this individual is all about. I think judges, as much as they can be annoying to our clients and our lawyers at times with the decisions that they make, try their best to balance that for the anecdotal and the sort of forensic side of things to make a decision about a sentence. Why is any sentence better than any other sentence? Somebody who kills somebody, we know has the capability of killing somebody. So they've demonstrated their dangerousness, right? So that might mean that it's better for them to be locked up for a longer period of time. Perhaps the same thing with a sex offender or the like. But there are all kinds of crimes that go on. The vast majority of them aren't sex offenses, and they aren't homicides. So we're making a decision that is a blend of data that's created by these instruments that is, at best, even without the bias baked in, only a predictor of what somebody in a group like that has done in the past, but doesn't tell you about what this particular individual would do. And you combine that with testimony from witnesses and what's the victim say, and what does the guy's mother say, and what does the person's psychologist say, and what were they going through a rough time for whatever reason that led them to burglarize a house and take stuff. Were they on drugs at the time and they're not now? All kinds of things that we talk about. The biggest problem I think we have is the over reliance on these documents alone as some predictor of future behavior. It does give us cover, because you can always say, well, look, the document said I could let them out, or the document said I'm going to keep them in. And but that's not really what judges are looking for. They want to make a decision based upon all the facts that they have available to them. And this is just one piece.
I appreciate that. Your usual calming influence.
Well, I find that if you be direct, people understand you better.
True. But I'm going back to them. What is the alternative?
Well, the alternative is to do what we have always done. And judges have always made decisions about sentences.
And I think the alternative is to improve the risk assessment so that it doesn't involve racial bias.
Well, I think
Because
the bias
without
arrives.
scientific tools to determine the actual risk, I think too often we're making decisions based upon inaccurate data.
Doesn't the bias get baked in before it ever hits the I mean, the bias gets baked in on the street, and the tool aggregates that bias over hundreds and thousands of people many, many times. So it's not necessarily the tool that's the problem. It's the fact that the tool bakes in the bias over a long period of time. You know, so to me, it's not that you don't necessarily stop using risk assessments. It's just treat them for what they are, which is a small piece of a bigger puzzle. They just can't be your driving force as to decisions you make for denying somebody's liberty when you know that in and of themselves they have a baked-in bias. I did want to say one thing. Oh yes, I'm sorry.
No, go ahead with that thought.
I was going to say something. Senator Benning had brought up the issue of two issues: one of conditions of release and of weight of the evidence hearings. And I do think, and I've observed the same thing, that we are having many more weight of the evidence hearings now than we used to in the past. And I see it as charging decisions, because weight of the evidence hearings are attached to only certain types of crimes where there's not necessarily a right to bail or there's a potential for life in prison. You don't have it on your run-of-the-mill, trespass case. You have them on sex cases and serious domestics and the like. And I think we're seeing a distillation of those charges. We're seeing less of the smaller ones being brought, we have more crimes now that have life in prison at the end of them. So I think as a proportion, we see more of them. And Judge Grierson and I have talked about many times about the use of conditions of release and what are we really doing. My observation, although I haven't studied it, I haven't done it, but my observation is we've had a turnover over the last 5 to 10 years, particularly the last 5 years, of prosecutors. And the older prosecutors who have retired and moved on, and the younger ones who have come in, have had different ways of addressing things. And the older prosecutors remember the days and practiced in the days when being released on your own recognizance was the vast majority of cases. The new ones who have come in have been brought up in a completely different legal atmosphere where we try to manage behavior of everybody down to every detail, and they attempt to do that with conditions of release. And if I put the Senate Judiciary Committee all on a list of like what might be considered the standard 10 conditions, violations would start hitting probably within the first month, because it's very difficult to live under conditions of release, even if you are a pro-social person. But if you've got other issues, it's next to impossible. So I think that there's a trend with newer prosecutors to rely on conditions of release in some attempt to manage behavior pre-trial that the older prosecutors never considered. I really just think it's a different culture of prosecution compared to what it was, more than 10 years ago.
I thank you for articulating that message as perfectly as I can imagine. Before Alice gets to ask her question, if I can jump in here, Alice.
Yeah.
I wanted you to know, Matt, that after 2 1.5-hour trainings with the Defender General, the hour-long training with the court staff, and 2 hours on my own of just studying the layout and the software, I filed my first 1-page document on e-filing on Monday. And it was a conditions of release modification and stipulation. But yesterday, I realized I didn't have conditions of release in another case, and I went in to the system to find that set of conditions. And although my client had several cases in the filing cabinet, my case wasn't one of them. So I don't know what's going on, but I just thought you should be proud of me because I actually filed my first document.
Although nobody can find it. Is that it?
No, I actually got a receipt that indicated they had it. But it was a different case. I went back in to look
Oh, I
at to retrieve the conditions of release, and they didn't have that file in the system yet. So it's a work in progress.
What?
Wanted to ask a question with regard to the weight of evidence. I mean,
Bev,
crimes require that you do a weight of evidence, or is the whole thing the option of the state's attorney?
Well, they only really come up in the life in prison cases and the very, very serious cases.
But could they come up in other cases?
Honestly, I don't know that I've ever paid any attention to it. I thought they were only in life in prison cases, but I could be wrong about that. They have to be very serious. Usually it's sex cases, or any other one that has the potential of being held without bail. If the state's going to want to hold you without bail, then you are, and so that's why it could come up in, I guess, some domestic cases where the state's asking to hold without bail. But usually you just see it in the very serious cases. It never even really occurred to me. I will tell you honestly too, in the very biggest cases, when I was doing homicides and sex cases, I would routinely just waive the weight of the evidence hearing. There's little, most of the time you don't get released, the vast, like 99%. And you end up strategically putting yourself at a disadvantage to the state when you do it. You better think that you have a really good chance of getting released on conditions before you start to point out the weaknesses of the state's case. So, to me, they were of little strategic value in how you handle the case anyway, particularly in homicide cases.
I'm thinking of the other side when maybe citizens feel that they aren't going to be protected, so they ask for a weight of evidence to kind of get everything out there. I guess it would have to be through the state's attorney or the AG's office. But
Yeah, I would have, honestly, I'll have to follow up on whether or not you get a weight of an evidence hearing. I believe it's only when the state is wants to hold without bail, and maybe Judge Grierson could pop in on that because he might know that. But it just never occurred to me when they were scheduled. I would either show up or waive them.
It is only on hold without bail cases.
Yeah, that's what I thought.
only allowed then? Is that
Yes.
what? Okay.
Yes.
Okay.
I don't know if Senator Sears is trying to talk to us or just.
We've expanded well beyond the bill, as been pointed out, although they are important issues in how judges make decisions on conditions of release and also on whether, what kind of information is available before you place conditions of release on an individual, and how realistic are those conditions of release. So I do think they're valuable discussions to have while we're taking up this bill, this simple little bill, according to Matt. But I don't know, without Eric here to make suggestions, how far we get this morning on it. But we could have a more extensive conversation about conditions of release. Senator White.
I was just curious about Matt's comment about the difference between new prosecutors and old prosecutors. And I wonder if there's any evidence that says that we have fewer actual recidivism or reincarceration because of this more attention to controlling behavior, or if we had more before when people were just released on their own recognizance. It would be very interesting to know kind of the effect and if it really has any impact on.
I know that the crime rate is effectively the same for the last 30 years. You know, so crime rate is different than arrest rate, but the crime rate, and that's incidents as opposed to arrests, is effectively the same. And actually, there's been, you know, little uptick in the last couple of years, but very little. I mean, I think Vermont. I just read something the other day. Vermont has dropped from second to fourth safest in the country, and we've been flopping back and forth between first and second with New Hampshire for a really long time. But you know, we're right up there.
Well, I was thinking in terms of people who were more controlled now, if that has more of an impact on their reincarceration,
Yeah.
the individuals, not the overall rate.
Right. Yeah, it's a good question.
Are the conditions of release realistic? So we
And do they
talked
really
about-
achieve what they're supposed to achieve?
Well, no, that's not my. Are they realistic that they could be adhered to? So, for example, guy's been driving for 20 years and he doesn't have a license, never had a license, and we're going to tell him not to drive. Do you think that he really won't drive, even though that's a condition of release? And then what is your plan when he violates that condition of release?
There was a guy I represented years ago, and he was a very serious alcoholic. And I appeared in front of Judge McCaffrey, who was one of my favorites. Just, you know, in any event, he had a sensitivity to people with addiction issues, and he was obviously involved in the Rutland Drug Court for a really long time. But this individual had racked up a lot of DUIs, and he had a condition that you don't drink, and he was actually on antabuse, and he was caught walking around the street, but he was obviously very intoxicated and throwing up because he was drinking while he was on antabuse. And I made an argument to the judge that you know, this is a guy who literally can't live in a world without alcohol. And I mean that, you know, we live in Vermont, and if there was alcohol in Saudi Arabia, he would find a way to get to Saudi Arabia to get that alcohol. And the judge says, I understand the choices he's making. And he looked at the guy and said, look, I'm striking this condition that you don't drink. And all I'm saying is, if you're drinking, don't leave your house. And the guy looked at him and was like, fair enough. And, you know, the case went from there, and I don't remember what ultimately happened to the case. I know the guy is still alive and around, and I see him in Rutland on occasion. But the bottom line is there are some out there who understand that there are conditions that just can't be met. And as long as you're not committing a new crime, you know, we can't save you from all your bad choices.
Well, one of the more difficult ones, and it's designed to protect the victim, is you shall not associate with so-and-so and so-and-so. Sometimes those aren't realistic, particularly when it's juveniles who are in school with so-and-so. very difficult to avoid them in school, which leads us to Willa Farrell. Thank you, Matt.
Thank you.
Who would, Willa,
Good morning.
please.
Good morning, Senator Sears. For the
Good
record,
morning.
Willa Farrell from the Attorney General's office. I guess I would just reiterate very briefly what you've already heard, that this bill would, in effect, codify what is current practice. Our pretrial service coordinators use the pretrial risk assessment tool developed by Ed Latessa, the ORAS PAT. There are 7 questions, and I can just give you a sampling of them because to buttress, I think, what Judge Grierson said, much of this information might well be available to the judge when they're making their decisions. So it's, failure to appear in the past 24 months. Have you been incarcerated? Are you employed? Residential stability, illegal drug use during the past 6 months, severe drug use problem, and age at first arrest. So our coordinators, who are all employees of community-based organizations, can access Vermont criminal history records, but they cannot access NCIC, the national database. Only law enforcement and others who are either employed by state or federal government, as I understand it, are able to access NCIC. So the practice is self-reporting and checking VCIC and telling the judge that that's how this information is gathered. But early on, judges would receive these and look in the file and see information that was more complete. So the reality is, even though prior to the pandemic, when coordinators were going into the correctional facility, the risk assessments were being done because we were required by law to do them, but they were not being they weren't being used. They were not useful information. So it's a risk-based assessment tool, but we're not using it the way it was designed to be used. It would be cost prohibitive to obtain the secure facility or have access elsewhere for people to access NCIC. And we feel that it's a practical reality to limit risk assessment to an even smaller group if a judge or a defendant wants it to happen. And I just would also note that they're voluntary. So when coordinators were going into the correctional facility, they would explain their role and offer, but the defendant, the person lodged, could decline to participate.
I understand they're
in
voluntary,
these
but
okay.
why is it cost prohibitive to get to NCIS information?
My understanding is you would have to be a state employee, or you would have to have a secure room inside a building such as a police department that our staff could, have some agreement.
Well, why can't we?
I beg your pardon.
We have memorandum. You are representing the Attorney General of the state of Vermont. I think that's a really important position. You are a state employee. I realize that the community justice centers are not state employees, but why can't the Attorney General access the criminal history records of people who are voluntarily wanting to have a risk assessment done of the ORASC? I don't understand why that's cost prohibitive. Police have that information, do they not?
We could explore the option of somebody calling from the correctional facility, our office, and somebody obtaining that information.
I think this is a poor excuse. I mean, if the defendant agrees and the information is available, it could be in the defendant's benefit or it could be in the state's benefit. I don't know, but they can all get the information. So I think keeping it from the public or keeping it from the decision maker is not a great idea. And if it's 7 questions and we need the criminal history record in order to fill out the form. I think we should try to find it. Now granted, it's a small number of people, but I don't see why we can't make that work.
Well, we could certainly look into exploring how we
Yeah,
might make that work.
I'm tired of hearing, I mean, if the Attorney General doesn't, I'm not trying to blame the Attorney General, by the way, but the Attorney General doesn't want the information and doesn't want to use risk assessments, then we should make that decision that we're not going to use risk assessments in making decisions about this number of people who are held on bail, and whether or not we should do a risk assessment, whether they should continue to be held. But if we're going to make decisions about this small number of people, shouldn't we have the best information available to us? And they voluntarily agreed to give us that information.
I think you make a good point, Senator Sears, and I think as the Defender General referenced earlier, the consensus of the stakeholders was that given the value of the work of pretrial services, it makes more sense to focus our resources on doing the needs screening and working with people when a judge orders. The risk assessment, we've not had a feeling that they're really useful, because when a judge, and obviously Judge Grierson could speak to this better than I, but a judge does have the information in the case file regarding prior failures to appear and that information. I think it's been a matter of trying to prioritize where we put our resources.
I think it's a matter of the course of least resistance, personally. And again, I'm not blaming the Attorney General's office. It's a habit that state government's gotten into, selling us on risk assessments several years ago, and the importance of them in making good decisions about incarceration of individuals and the value of those risk assessments. And now saying, well, they aren't that valuable. Troubling to me.
It might help to provide a bit of history. In the last few years, there's been a multi-stakeholder group supported by the National Governors Association that has been looking at pretrial services and led to some of the changes, as I understand, around bail in the last few years. And one area we looked at were risk assessment. Like, what would be a risk assessment that could be done perhaps with information that is in records where you don't have to interview somebody. And there was a particular tool identified that's being developed by the Arnold Ventures, the PSA, and is used in Kentucky and some other states. Crime Research Group did a retrospective study looking at that tool compared to people who had already been through the criminal justice system in Vermont. And they, I think their conclusions were that tool was not useful for Vermont. So there's been, I think, a rigorous and concerted effort to look at what would be an alternative risk assessment tool that could be used. And we've yet to identify one. So the idea here was, in the interim, to have the law reflect the reality that we will continue to do the risk assessments when we're able to go back into the correctional facility. But the judges really are not finding the information to be useful.
Thank you very much. Other questions for Willa? Thank you. We've got to be on the floor today at 11, unfortunately. And I say unfortunately. Thank all the witnesses this morning, and Peggy, I think it's time to end the meeting.
Okay.